Alaska just handed gun rights advocates one of the most significant state-level victories in the country this year. The Alaska Supreme Court issued a ruling that crushed a gun carry ban that had been in place and had been defended by the state's gun control advocates as a model of reasonable regulation. And the way this court got there, the legal reasoning, the specific language, the framework it established, matters far beyond Alaska's borders. Because what the Alaska Supreme Court did is not just strike down one local carry restriction. It built a constitutional blueprint that Second Amendment advocates in every other state can use, and that gun control advocates in every other state now have to fear. This is the kind of decision that gets buried. Not because it is not significant, it is enormously significant. It gets buried because state Supreme Court decisions on gun rights do not generate the wall-to-wall cable news coverage that federal rulings do. The mainstream media is not going to spend 3 days analyzing what the Alaska Supreme Court said and why it matters. So most gun owners across this country are going to go about their week having no idea that a major legal foundation was just laid in their favor in Juneau. That ends right now. I am going to break down exactly what the Alaska Supreme Court ruled, why the legal reasoning is more important than the specific outcome in Alaska, what this means for carry restrictions in other states, what gun control advocates are going to try to do in response, and why this ruling fits into a much larger national legal picture that is moving faster and in a clearer direction than most people understand. Subscribe right now because state-level Second Amendment developments like this one are exactly what this channel exists to track. The national picture is built one state decision at a time, and you need to know when a significant piece of it just landed. Let me start with what happened and why it matters that this came from a state Supreme Court rather than a federal court. There is a tendency in Second Amendment coverage to focus almost exclusively on federal courts, on the Supreme Court of the United States, on the circuit courts of appeal. And those courts absolutely matter. The Heller decision, the McDonald decision, the Bruen decision. These are the foundational pillars of modern Second Amendment law, and they came from the federal system. But state Supreme Courts matter enormously as well, for reasons that do not get explained often enough. First, state Supreme Courts are the final word on questions of state constitutional law. Every state has its own constitution. Many state constitutions have their own right to keep and bear arms provisions, and many of those provisions are actually written more broadly and more explicitly than the federal Second Amendment. Alaska's constitution is one of them. Alaska's right to bear arms provision has language that in several respects provides stronger textual protection for gun rights than the federal Second Amendment does. When the Alaska Supreme Court interprets that language and builds a legal framework around it, that framework is binding in Alaska, regardless of what federal courts do. It cannot be appealed to the Supreme Court of the United States on state constitutional grounds. It is final. Second, state Supreme Court decisions on gun rights create persuasive authority that travels. When a well-reasoned state Supreme Court opinion applies Bruin's historical tradition framework, when it analyzes the original meaning of a right to keep and bear arms provision, when it identifies the specific categories of restriction that cannot survive constitutional scrutiny, other courts read that opinion. Lawyers cite it in briefs filed in other states. Judges reference it in their own opinions. The legal reasoning circulates through the national litigation ecosystem and influences outcomes far beyond the specific state where the decision was issued. Third, and this is the one that does not get discussed enough, state Supreme Court victories are significantly harder for gun control advocates to work around than federal victories. When the Supreme Court of the United States issues a ruling that gun control advocates dislike, they respond by going to Congress, by pushing state legislatures to enact workaround legislation, by crafting new regulatory frameworks at the federal agency level. They have multiple avenues of response. When a state Supreme Court issues a ruling based on the state constitution, the state legislature cannot simply pass a new law to override it. The only route to overriding a state constitutional ruling is amending the state constitution, which is deliberately difficult, or waiting for the court's composition to change. In Alaska's political environment, neither of those paths is quick or easy. This ruling has staying power that a lot of people are underestimating. Now, let me get into what the court actually said, because the substance of this ruling is where it gets both important and genuinely interesting from a legal standpoint. The case arose from a carry ban that had been imposed in a specific category of public spaces in Alaska. The government defending the ban argued that it fell within the range of reasonable regulations that states have historically been permitted to impose, that it served compelling public safety interests, and that it was consistent with the kind of location-based restrictions that even pro-gun Supreme Court decisions have suggested might survive constitutional scrutiny. On paper, that was not an unreasonable set of arguments. Location-based restrictions have been one of the primary tools gun control advocates have reached for since the Bruin decision closed off a lot of their other options. If you cannot restrict who can carry, and you cannot impose extensive permitting requirements, and you cannot require proof of special need, maybe you can restrict where carrying is permitted. Maybe you can define enough sensitive places with enough breadth that the practical effect of carry rights is substantially limited even if the formal right exists. The Alaska Supreme Court looked at that strategy and dismantled it. The court applied the Bruin historical tradition test and asked a foundational question. Is there a historical tradition in America rooted in the founding era of prohibiting the carrying of firearms in the category of location at issue here? The state argued that there was. It pointed to historical restrictions, to the kinds of sensitive place designations that the Bruin majority itself had suggested might be constitutionally permissible, to analogous historical regulations that it argued provided sufficient historical grounding for the ban. The court was not persuaded. It went through the historical record carefully, applied the analytical framework that Bruin established, and concluded that the specific ban at issue did not have the kind of deep historical tradition behind it that the Constitution requires for a firearms restriction to survive. The ban fell. But here is the part that matters most for the national picture. The court did not just say this specific ban fails. It explained in detail why it fails. It laid out the analytical framework it used to reach that conclusion. It identified what kind of historical evidence would and would not be sufficient to justify a location-based carry restriction. It explained what the government needs to show and how it needs to show it. That analytical framework is now part of Alaska's constitutional law. It is also a detailed, carefully reasoned template that lawyers and judges across the country can work with. The court was especially pointed in addressing the argument that modern public safety concerns can substitute for historical tradition in the constitutional analysis. Gun control advocates have increasingly argued that even if a specific restriction lacks precise historical analog, the general historical tradition of legislating for public safety provides sufficient constitutional grounding. The Alaska Supreme Court rejected this argument directly and emphatically. Modern public safety rationales, however compelling they might be as policy arguments, do not supply the historical tradition the Constitution requires. If the restriction does not have genuine roots in the founding era framework for regulating arms, the contemporary public safety case for it does not save it. That holding is going to be cited in Second Amendment cases across the country for years. Let me talk about what this ruling means practically for gun owners in Alaska, because that is the immediate on-the-ground impact, and it is significant. The carry ban that was struck down had been preventing lawfully armed Alaskans from carrying in spaces where they now have a constitutional right to be armed. That changes immediately. Gun owners in Alaska, who were previously forced to leave their firearms behind when entering the restricted spaces covered by this ban, can now carry in those spaces lawfully. That is a concrete, immediate expansion of the practical ability to exercise Second Amendment rights in Alaska. But there is a larger context that Alaska gun owners need to understand as well. This ruling signals how the Alaska Supreme Court is going to approach future Second Amendment challenges. It signals the analytical framework the court will use. It signals the evidentiary standard the government will have to meet to justify any firearms restriction it wants to defend. For Alaska gun owners and Alaska gun rights advocates, this ruling is not just a victory in one specific case. It is a signal about the direction of Alaska constitutional law on the right to keep and bear arms going forward. Future restrictions that cannot satisfy the historical tradition analysis the court applied here are going to be vulnerable, and the gun rights litigation community in Alaska is going to use this ruling as the foundation for challenging restrictions that have survived until now because they had not been subjected to the kind of rigorous analysis this court just applied. Now, let me talk about what gun control advocates are going to do in response, because understanding the resistance strategy is as important as understanding the victory. And make no mistake, there is going to be a resistance strategy. Gun control organizations do not accept court decisions they disagree with. They adapt. They find new arguments. They look for new mechanisms to accomplish the same goals through different legal means. That is the pattern, and it is going to repeat here. The first thing gun control advocates are going to do is argue that this ruling is narrowly confined to its specific facts and should not be read as broadly as gun rights advocates want to read it. They are going to argue that the specific location covered by this ban had particular characteristics that made this particular restriction especially vulnerable, and that other location-based restrictions with different factual profiles might survive the same analysis. They are going to try to minimize the precedential reach of this ruling by emphasizing everything that makes this case unique rather than typical. This is a standard legal strategy, and it is not entirely without merit. Courts do distinguish cases based on their specific facts, but the quality of the Alaska Supreme Court's legal reasoning in this case makes narrow confinement difficult. The framework the court established is general. The analytical tools it applied are widely applicable. The principles it articulated extend well beyond the specific location at issue. The second thing gun control advocates are going to do is push for legislative responses. Even though the legislature cannot directly override a state constitutional ruling, it can try to craft new restrictions that it believes can be distinguished from the one that was just struck down. Watch for Alaska state legislators in the coming months introducing new location-based restrictions drafted specifically to try to satisfy the historical tradition analysis this court applied. Watch for arguments that new restrictions are different in relevant ways from the one that failed. The legal cat-and-mouse game between court decisions and legislative responses is going to play out in Alaska just as it has played out in every other state that has seen significant Second Amendment litigation. The third thing, and this one matters for the national picture, is that gun control organizations are going to engage in what amounts to a national litigation coordination effort to limit the reach of the Alaska ruling's reasoning in other states. They have the resources to do this. Organizations like Giffords, Everytown, and the Brady Campaign maintain sophisticated legal teams that coordinate litigation strategy across jurisdictions. When a ruling like this comes down, those teams analyze it immediately, identify its strongest arguments and its most vulnerable points, and develop counter-arguments designed to prevent those arguments from spreading to other states. Understanding that this coordination is happening is important for understanding why gun rights litigation organizations also need sustained resources and support. Let me put this ruling in the broader national legal context, because it does not exist in isolation, and understanding where it fits in the larger picture makes it more significant, not less. We are in a period of extraordinary legal activity on Second Amendment issues. Since the Bruin decision in 2022, the rate of Second Amendment litigation across the country has been higher than at any point in the history of the individual right to keep and bear arms as recognized by the courts. Cases are being filed in federal courts, in state courts, on questions ranging from who can possess firearms to where they can be carried to what features they can have to how they can be stored. The litigation ecosystem is producing decisions at a pace that makes it genuinely difficult, even for experts, to track everything that is happening. Within that context, state Supreme Court decisions like Alaska's play a specific and important role. They develop the doctrine in ways that fill gaps the federal rulings have left. The Bruin decision established the historical tradition test as the governing framework, but it did not resolve every application question. It did not specify exactly what kind of historical evidence is sufficient in every factual context. It did not draw every line that needs to be drawn between permissible and impermissible location-based restrictions. Those lines are being drawn now, case by case, in federal and state courts across the country. The Alaska Supreme Court just drew one of those lines. It drew it clearly, it explained its reasoning, and it will influence how other courts draw similar lines in similar cases. The broader trajectory of this litigation is moving in a direction that gun rights advocates have cause to be encouraged by, and that gun control advocates have genuine cause to be worried about. State after state, where courts have rigorously applied the Bruin historical tradition test, has seen restrictions fall. The historical record simply does not support the breadth of regulation that gun control advocates built over the past century. The permit systems, the carry restrictions, the categorical bans on certain types of locations, the training mandates. When subjected to honest historical analysis rooted in the founding era, most of these modern regulatory inventions do not have the historical grounding the Constitution now requires. Alaska just made that point again clearly at the level of its highest court. There are some important nuances to the national picture that you need to understand. However, because the legal landscape is genuinely complicated, and oversimplifying it in either direction leads to a distorted picture. Not every court is applying the Bruin test in the same way. Some federal circuit courts have been significantly more willing than others to find historical analogs that justify modern restrictions. The question of how closely a modern restriction needs to resemble a historical one to be constitutionally sustained has not been definitively answered at the national level. There is genuine circuit court disagreement on some of these questions, which means the Supreme Court of the United States is eventually going to have to weigh in on aspects of the doctrine that Bruin left open. When it does, the reasoning of well-crafted state Supreme Court opinions like Alaska's will be part of the intellectual landscape the justices are working within. Now, let me talk about what gun owners across the country, not just in Alaska, should take from this ruling, because the broader lessons here matter for everyone who cares about the practical exercise of Second Amendment rights. The first lesson is that state courts matter, and state constitutional provisions matter. If you are a gun owner in a state where the state constitution has a right to keep and bear arms provision, and almost every state does, you need to understand what that provision says and how your state's courts have interpreted it. In some states, the state constitutional provision provides stronger protection than the federal Second Amendment as interpreted by the current Supreme Court. In others, state courts have interpreted state provisions narrowly in ways that provide less protection. Knowing where your state stands on this is essential to understanding the full legal landscape governing your rights. The second lesson is that location-based restrictions are the next major battlefield in Second Amendment litigation, and that battlefield is going to be fought out over the next several years at both the state and federal levels. Since Bruin closed off so many of the other mechanisms gun control advocates relied on, the push to expand sensitive place designations has accelerated dramatically. Airports, public transit systems, parks, restaurants that serve alcohol, parking lots, shopping centers. Gun control advocates in many states have been pushing for sensitive place designations that, taken together, would cover so much public space that the practical right to carry would be effectively nullified even if the formal right is acknowledged. The Alaska ruling pushes back against that strategy powerfully and directly. But the fight over where the lines are on sensitive place restrictions is going to continue for years. The third lesson is about the importance of litigation support. The victory in Alaska did not happen by accident. It happened because lawyers invested time, resources, and expertise in building a legal challenge, taking it through the court system, and presenting the strongest possible constitutional arguments to the Alaska Supreme Court. That work costs money. It requires organizational infrastructure. It requires the kind of sustained commitment that gun rights organizations provide when they have the resources to do so. The Second Amendment Foundation, the Firearms Policy Coalition, Gun Owners of America, and state-level gun rights organizations across the country are doing this work constantly in courts across the country, on cases that rarely generate national headlines, but that collectively build the legal architecture within which these rights are exercised. If you care about outcomes like the Alaska ruling, the single most direct way you can contribute to more of them is to support the organizations doing the litigation. The fourth lesson is about staying informed and staying engaged at the state level specifically. National elections and national politics get enormous attention. State-level developments get far less. But the reality of Second Amendment rights in your daily life is determined at least as much by what happens in your state legislature, your state courts, and your local government as by what happens in Washington. The carry ban that the Alaska Supreme Court just struck down was a state-level restriction. It would not have fallen without state-level litigation. The workarounds that gun control advocates are going to attempt in response to this ruling will be state-level legislative and regulatory actions. Tracking those developments, understanding them, and engaging with them as a citizen is essential to protecting the practical exercise of rights that courts are increasingly recognizing as constitutionally protected. Now let me be direct about what this ruling is not, because accuracy matters as much as enthusiasm when covering legal developments like this one. This ruling is not a blanket invalidation of all location-based carry restrictions in Alaska or anywhere else. The Bruin decision itself acknowledged that some sensitive place designations have sufficient historical grounding to survive constitutional scrutiny. Government buildings, legislative chambers, courthouses, polling places. There is historical tradition behind restrictions in these specific locations that is likely sufficient to sustain them under the Bruin framework. The Alaska ruling did not change that. What it changed is the legal fate of restrictions in locations that do not have that historical grounding. The distinction between locations with sufficient historical tradition and locations without it is going to be litigated extensively. This ruling helps define that distinction in Alaska, but does not resolve it comprehensively everywhere. This ruling is also not a guarantee that similar restrictions in other states are going to fall immediately. The Alaska Supreme Court's decision is directly binding only in Alaska on questions of Alaska constitutional law. Its reasoning is persuasive authority elsewhere, not binding authority. Courts in other states are going to make their own assessments of similar restrictions under their own state constitutional provisions and under the federal Second Amendment, as interpreted by Bruin. Some of those courts will reach similar conclusions. Others may distinguish this ruling in ways that allow different restrictions to survive. The litigation continues, and this ruling is not the final word in Alaska either. Gun control advocates are going to challenge new carry exercises. They are going to push for new restrictions drafted to try to satisfy the historical tradition test. They are going to look for factual distinctions that might allow other location-based bans to survive where this one did not. The Alaska Supreme Court is going to hear more Second Amendment cases. The doctrine is going to continue developing. This ruling is a major point on a trajectory, not the end point of one. Here is the bottom line on what just happened and why it matters. The Alaska Supreme Court issued a ruling that struck down a gun carry ban by applying the Bruin historical tradition test rigorously and without flinching from where that analysis leads. The court's reasoning is clear, detailed, and will travel. It establishes an analytical framework that is going to influence Second Amendment litigation in other states. It signals how Alaska's highest court will approach future gun rights cases. It delivers a concrete, immediate expansion of carry rights for Alaskan gun owners. and it represents one more significant point in a national legal trajectory that is moving towards stronger constitutional protection for the practical exercise of Second Amendment rights. Gun control advocates are going to respond. They always do. They are already working on legislative responses, litigation coordination, and new regulatory frameworks designed to accomplish, through different means, what the courts have been striking down. Understanding that resistance strategy is as important as celebrating this victory. The fight is not over with this ruling. It is entering its next phase. Subscribe right now because that next phase is going to produce major developments at both the state and federal level over the coming months, and you need to track them as they happen. The national picture on Second Amendment rights is being assembled one court decision at a time. Alaska just contributed a significant piece. More are coming. Share this with every gun owner and every Second Amendment advocate you know, because this ruling is not getting the national attention it deserves, and the people it matters most to are the least likely to hear about it from mainstream sources. Stay informed. Stay engaged. The legal war for the practical exercise of your constitutional rights is being fought right now in courts you are probably not watching. Start watching.